welcome to our seminar. I'm Glenn Sykes. A little bit about me. I've been a cancer patient since December 2010. I've been treated for metastatic renal cell carcinoma since June of 2015. I've had a range of treatments during that time, of course. I started this past, present, and future series along with Judy Nicholson to cover some topics that I didn't see very well covered in a lot of the patient education seminars that we attend. They tend to be very treatment focused, which is great because that's a good place to get that information. But I also feel there were topics that were important to cancer patients that I didn't see being covered as in depth as I think they could be. So I started with a focus group, I think in the spring of 2023, to boost a list of important topics. We have had experts come and speak to us about palliative care, hospice care, spirituality. Last time we even had a death doula speak to us as well. And one of the important topics that people want to hear about was the topic we're going to talk about tonight. Estate planning, for lack of a sexy title, but it's a good one. I think when I think about this series, I think about a quote that I came across in an article I read on the death positive movement, which I really think captures the essence of this series. And it is a quote from a rabbi, in fact. And in it, the quote, he said, "We're not talking about death, but we're talking about one's life, given the realities of death." And I think as cancer patients, maybe those realities hang a little closer to the horizon than they might be for other people. I know they do for me, and I'm happy to see the people here because that suggests to me it may be hanging there for those people as well. So, as I mentioned, today's session is about estate planning. As you're about to discover, it's a very broad topic under which you will find the best ways to document your wishes as you manage a serious illness and all the roads it may lead you down. On the seminar, I had sent out ahead of time and asked you to review them. No one's going to check that. I was surprised to hear from Monica that 68% of Americans have not done a will. And as you learned in Monica's seminar, some really famous people that probably had the resources to create a will missed that boat as well. And a will is really just one aspect, but really foundational aspect of estate planning. I think of the goals for tonight's seminar, and there are two that I think of. One is to provide a spark, a catalyst for those in attendance that have not started the estate planning process, and to encourage them to take that next step. And for those that already have, and I throw myself in that group as well, that have already completed them, understand that what things that you might want to review and update or you haven't completed. So sort of a completeness check. Let me introduce Monica Bryant. Monica Bryant is the Chief Operating Officer at Triage Cancer. I am so thrilled that she agreed to join us. I can't think of anyone more qualified to speak about this topic. Triage is a nonprofit organization that provides education on the practical and legal issues that impact those of us living with cancer, whether we're a patient, our caregiver, our family member. In the chat box, I did list their website. I encourage you to go onto that website, not during tonight's seminar, but afterwards, because there is an amazing wealth of information on there. And we're really thankful that we can find things like that. Monica wears many hats as a cancer rights attorney, speaker, and an author. She's dedicated herself to improving the quality of information on health-related issues for both patients and caregivers. She's provided, now get this, I was amazed when I read this. She's provided more than 1,000 educational seminars to a range of audiences. Early in her career, she also worked in the office of both a U.S. Congressperson as well as a U.S. Senator in Washington, D.C. And if you would like to learn a little bit more about Monica, go to that website. You'll find her full bio there. So welcome, Monica. Monica, it's great to have you here today.
Thank you so much for that lovely introduction. I'm happy to be here. I think maybe the fact that I've given 1,000 seminars speaks to my inability to say no. But honestly, I, really feel strongly that I want people to be able to get their questions answered. So I hope for all of you who have taken the time out of your evening tonight to join us, that you won't be shy and ask your questions, because if you have it, chances are somebody else has it.
Great. It's like you read my notes, because I just talked about people not being shy. So now 1,001 seminars, which is great. I have prepared some questions here, in fact, a few pages of questions, but I really just hope to only have to ask a couple of those to just get the discussion going. I try to keep my starting questions broad. I will stick to those for about 20 minutes, and then I'm going to ask the audience for their questions. This is the chance to really tailor the seminar to your own needs. You can see that we have a intimate sized crowd. So I think everyone will have a chance to ask their questions and get those answers. And we should take advantage of this amazing experience that Monica represents, and she's sharing her time with us tonight. As she said, I hope you're not shy about speaking, but if you are, prefer to use the chat feature for your questions. I'm happy to review those when we get to that point. So I'll check that once we get to that part of the seminar. I already did see someone had asked a question if this was going to be recorded. And I think the answer is yes. And if you're on the Judy Nicholson site or you've registered for this seminar, I think that you will get notice about the recording. Is that right, Linda? Good. Linda's shaking her head, so that's a good sign. Linda is from Judy Nicholson Foundation.
Yes.
Yes, great. Thanks. So to start off with, let me ask, I've had people I know well say to me, I don't have much, so why should I bother with an estate plan? Maybe it's that grand sounding word of an estate that conjures up some image in our head, that we have to have a wealth of assets available to us. But really, the thing I've learned is that estate planning really should matter to everyone, not just people who own estates. I heard you say that estate planning can come from a loving place in your heart for family and loved ones, not just a sad place. And before I have you answer that question, I used to work at a university, and I was just on the phone with one of my former students last week, and he was sharing that his father passed right around the holidays. And, without me prompting him, he said, it was so great. My father had left all his wishes for us. And while we were sad, we weren't burdened in that sadness to deal with a lot of unknowns about what he would like to have done. He became ill rather suddenly and passed rather quickly. But in that intervening time between sickness and death, there were a lot of decisions to make. And Ryan said to me, it was so great that he already had made his wishes known to us, and we knew where to find those wishes. And that just made that process so much smoother. So it was like he had read these notes, because that was exactly the point that I remembered, because I think it's a good place to come. So Monica, that's a pretty broad question, but let's get going on the topic.
Well, I mean, I think that you really summed it up quite well in that, when people talk about estate planning, a lot of times people will avoid it because ultimately we are talking about either your death or something happening to you where you are then in a position where you're unable to express your wishes. And none of us really want to be spending a whole lot of time thinking about that, I would venture to guess, right? So at its core, it's a hard thing to talk about. It's a hard thing to think about. However, and I say it in every presentation I give on this topic, there is one thing that is absolutely inherently true for each and every one of us. And that is, at some point, we are all going to die. Now, certainly, we hope it is far away in the future, but we also don't know what's going to happen to us tomorrow, right? And so estate planning isn't an end-of-life conversation. In fact, I think everyone over the age of 18 should be thinking about their wishes. And so, your former student really summed it up perfectly in that it's such a loving thing to do, because it takes those decisions off the shoulders of loved ones at a time when those people are dealing with their own emotions and their own grief and their own loss. And then they're not also having to think about, what kind of funeral did dad want? So that's why I talk about it as a really loving thing to do. Also, none of us have a crystal ball. None of us know when that day is going to be, right? Or most of us don't. So again, I like to take estate planning out of the conversation of end of life or palliative care, any of those things. It is simply an adulting thing. It is something that all of us should do as an adult. But to your earlier point about an estate, right? Like, what if I don't have a lot? Why do I need to create an estate plan? There's a couple pieces to that. So the first is, if you don't create the estate plan, even if you only have a little bit, whatever that means to whomever you're talking to, because it's all relative, right? Don't you want to have some control over what happens to that little bit? You've probably worked very hard for that. You probably have some thoughts on what you would like to have happen to it. Most people don't want it to go to the government, which is a strong possibility in certain situations. You also lose all sorts of control. So if someone doesn't create their estate plan and they pass away, whatever property they have amassed then gets divided up by law. And so if the only closest family member you have is your, estranged ex-husband and you die, then that might be the person who gets your property, whatever that property is. And so again, this is about taking back some control and having some choice. And I think that even though I don't think estate planning is something that people with serious medical issues need to do, I do think it's a time when a lot of control gets taken away from you. A lot is happening to you physically, mentally, emotionally, sometimes financially. So here's a place where you get to take back some control and decide what you're going to do with whatever property you have, whether that's something you consider to be a lot and worthy of calling it an estate, or if it's just a little bit.
Thanks. Monica, I appreciated your point. I think in the seminar, speaking of control, that you find yourself to be sort of a type A personality. I can relate to that.
It is definitive.
Okay, I can relate to that, and you're right. This is a way to make sure that your wishes you have input in now at a point that you can have input, which is great. So let's get into it. Thanks for that great start. What are the major documents of a good estate plan? What's distinctive about each of them? And aside from those essential documents, I consider probably some foundational documents. Are there other ones that we may not get to all of them tonight, but are there other ones that are essential that you also consider close to being essential part of an estate plan?
So I always say there's 4 documents everyone over the age of 18 should have. The first is a will, which is, to your point, the most foundational, basic estate planning document. It's where you are going to deal with the distribution of your property when you pass away, and it's where you can deal with the guardianship of minor children. You're going to deal with that in a will. Now, sometimes, to your point earlier, people will say to me like, well, I don't really have a whole lot, so do I really need a will? Many times, though, people don't think about their property or their estate in totality. A lot of times people think about estate and they're like, oh, it's a home or it's land, it's property. And that is one type of property. It's referred to as real property. But you might have personal property that is worth something. So, my mother was just telling me about her mother's silver set, and that is very important to her. And that actually might have some monetary value. So even though it's movable and it's not real property, she might want to include that in her estate plan. Then there's a lot of things that many of us amass over the years that might not have a financial value to them or a significant financial value to them, but they might have a really strong emotional or sentimental value to them. And that's where your will is a really useful tool to be able to say what you want to have happen to those things. So I often use examples of things like record collections or jewelry or books. If someone has created a great book collection, I always use the example of my family's cedar chest. That is one of the few things that has come down from multiple generations. If I were to go sell it, probably a couple $100, but the sentimental value of it is significant. So the will is the place where you're going to deal with both real property that could have a substantial, monetary value to it, and then also the personal property. So I also just want to encourage, as I go, if people have questions about these documents, please feel free to, do you want people to throw it in the chat box, Glenn? Is that?
Yeah, yes. If they
Okay.
want to, they feel like they just want to get, and I understand that. If you have a question on your mind, you just want to get off your mind, put it in the chat box. If you feel like you can hold on to it, then you can ask it later. Absolutely.
Okay, perfect. I just didn't want to like give you a laundry list of things and then people are like, wait, what was my question? So will is the number one document. The second is the power of attorney for financial affairs. And this actually isn't about your death per se, but it's about picking someone, otherwise known as an agent, to make decisions on your behalf. And this could be in a couple different circumstances. So it could be a situation where you literally cannot communicate your wishes and actively, carry out the financial pieces that you need to. Maybe you're in a car accident and you're in a coma. Who's going to pay the medical bills? Who's going to, pay your mortgage? Who's going to maybe you have to apply for Social Security disability insurance or Medicaid or Medicare. Who's going to do that for you if you can't physically or mentally do that? You could name an agent to be your power of attorney for financial affairs. Sometimes, however, someone might still be able to communicate, but could potentially use some support. And I definitely see this in the cancer community. So someone's perhaps in the midst of treatment, they're overwhelmed by, they're dealing with the physical aspects of treatment, the emotional aspects of treatment, and like the paperwork, handling medical bills, fighting with insurance companies, filling out applications. That's like a whole nother job. Mm-hmm. And so even though they could do those things, instead they're going to name an agent to help them do those things. And so that's the benefit of that power of attorney or financial affairs, is you can set it up either way, where you could sign it today and it wouldn't go into effect unless you became incapacitated, or you could sign it today and it would go into effect today, and then that person could help you throughout. So that's document number 2. Document number 3 is your power of attorney for healthcare. So here, similar concept to the power of attorney for financial affairs, except now you're naming someone to make medical decisions on your behalf. Similar concept in that you could name that person to make medical decisions on your behalf. It could be the same person as your financial power of attorney, but you still need both forms. But it doesn't have to be. And many times I see people default to their spouse or their partner to be these agents, which is fine. But I think that there needs to be more thought that goes into it before just assuming like, oh, my partner or my spouse will handle this. And the reason I say that is if you think about the purpose of these documents, which is generally someone to step in a crisis, who is most likely to be most upset about the situation? Your spouse, right? Or your partner. And so for some people, that's not going to matter. They're still going to be able to be level-headed and handle all the business, and it's not going to be a problem. For other people, maybe that's not the best person for you to step in. So it can certainly be the same person. It doesn't have to be. If you've watched the webinar, I'm sure I gave this example because I generally do, but my lovely husband.
It's a good one.
Yes, I love my husband to the ends of the earth, and he is a wonderful human. He is incredibly financially savvy. I would have zero qualms with him making any sorts of financial decisions on my behalf. So he is my financial power of attorney. The man also calls every pill he takes an aspirin, whether it is a vitamin, whether it is an Advil, and he goes to the doctor and he's like, I'm taking aspirin. And the doctor freaks out because he's like, what? You're going into surgery. You can't be taking aspirin. I'm like, no, he took Advil. It's fine. Right? This is not the man I want making medical decisions on my behalf. He knows it. He's fine with it. But my point here, in a little bit of levity, is that sometimes it's not the same person that's the best person to make those decisions. Maybe it's your very level-headed nurse best friend, and that's the best person to make those decisions. So I think it's just important. It's a lot to ask of somebody. But I do think it's important that you really think through, like, in a true emergency or in a crisis situation, who's the person that's going to be best to make these choices for me? So that's document number 3. And then document number 4 is sometimes referred to as a living will. I frankly hate this term because I think it causes all sorts of confusion for people as to what it actually is. I prefer calling it instructions for healthcare because it's more descriptive. And this is a document where you are going to write down or choose medical treatment you do or don't want in the event that you're unable to express it. And it could be specific treatments. It could be about comfort care. So for example, in my instructions for healthcare, I am very clear that I expect pain management because we live in an era that we have plenty of medications. I do not need to be in pain. Some people might say, you know, because of their religion, they don't want anything, no blood transfusions, and they can write that in their instructions for healthcare. When you put the instructions for healthcare together with your power of attorney for healthcare, that's more broadly called an advanced healthcare directive, because you are in advance creating some directions around your healthcare. And sometimes people will ask me, well, okay, if I named an agent, why do I need to spend time writing down my wishes? I've already dealt with it by naming an agent. And that's true. You can just name an agent. But I do think it's helpful to also create those instructions for healthcare because it provides some guidance for your agents about what you would or would not want. Conversely, someone might say, well, if I've written down what I do or don't want, why do I need an agent? Again, you don't have to have one, but it definitely gets helpful because most people, when they are creating their instructions for healthcare, cannot come up with every possible medical scenario from now until the end of time and then make a decision about it. And so that's where then, if there is something that comes up that's not addressed by your instructions for healthcare, your agent could potentially step in and make those decisions using what you've included in your instructions as guidance, as guideposts. So those are really the 4 documents that I think every single person should have.
Great. Thanks, Monica. And I just want to point out, if you go to the triagecancer.org site, I have that in the chat box, you will find resources to amplify what you just heard and to even help you, go those next steps. So those are the 4 foundational documents. And you don't necessarily have to go into depth here, but are there other documents? Because maybe people have heard about these documents before. Are they part of an estate plan? So there are other, documents that are complementary to the estate planning trust?
Absolutely. So, because Linda asked it in the chat, I'll start with a trust. So trusts are a legal tool where you transfer ownership of property into the name of the trust. And there are multiple types of trusts. One of the most common types is a living trust. And the reason it's common is because it's very flexible. So essentially what someone would do is they would transfer, let's just use a house as an example because it's kind of the easiest. They would transfer ownership of their home into the trust. The trust is now the legal owner of that home. But if I'm doing that, I then become trustee. So I'm the person that is in charge of managing the trust. So that means I can put more things in the trust. I can sell things out of the trust. It's living, it's breathing, it's totally malleable until the moment I die. And then the terms of the trust are set. Why might someone create one of these trusts? There's a couple reasons. Primarily, it helps you avoid something called probate, which is the legal process of which property gets distributed. And even if somebody has a will, they still have to go through probate for whatever is in that will. And then creditors get to come in and take their share. Sometimes that means that, someone the house has to be sold if it's going through probate, and then creditors get to take their pieces. When the house is in the trust, you don't go through probate. And so the property is distributed by terms of the trust. There are also some other benefits to it. So, for example, parents can use a trust as a way to protect perhaps minor children, because you can put some parameters around how the property gets distributed. For example, you might say, my child only gets access to their portion of my estate until they graduate from college or until they turn 30 or whatever. It could be about because they're minor children. It could also be about maybe it's a situation where the adult child has a disability and isn't able to manage the assets on their own. Or I've seen situations where family members have gambling problems. So the trustee wants to take advantage of the family member, but if they were just to give them a lump sum, it would, disappear. But this way they're able to do things like have the trust pay for that family member's rent or food and still have some control over it. So trusts create protection. They create the ability to have some parameters around how the property gets distributed. Typically property, typically it's real property. So things like land and homes, or things like accounts. So 401ks, you can actually make the beneficiary of your 401k the trust. So if you were to pass away, then the trust, the 401k gets paid out to the trust. So they're slightly more nuanced. And, I generally say that you don't need a lawyer to create an estate plan. Trusts might be the one exception to that. You don't have to have a lawyer. But unless you're really confident in what you're doing, I would be careful, because you are actually transferring ownership away from yourself into the trust. So you want to make sure that's done correctly.
Anything else that you would think kind of exists in that sphere of estate planning?
Yeah, so there's some other documents that are other types of advanced directives that aren't necessarily going to be appropriate for everybody. So a really common one is a do not resuscitate order, or a DNR. And this is a document that you would sign in consultation with your healthcare provider that would tell first responders and emergency rooms that if you stop breathing or your heart stops, they should not perform CPR. Generally, and I'm obviously generalizing here, a DNR isn't going to be appropriate for someone who is healthy and can, otherwise be resuscitated. Generally, you're only going to see DNRs in situations where perhaps someone is of a certain age and they feel like it is now appropriate for when my time comes to be let go, or if someone has an advanced illness where they feel like they're okay with the idea that if their heart or breathing stops, that they don't want resuscitation. There's also, in some states, not every state, a form, and it's called slightly different things depending on where you are, but the acronym is called a POLST form. Mm-hmm. It's a physician's order for life-sustaining treatment. And this, again, is something that you would create or discuss and have signed by you and your healthcare provider, where you're, again, telling first responders the types of treatment you do or don't want. POLST forms are only appropriate for someone who is medically frail or really at advanced disease. Usually they're on, bright colored pieces of paper. They're taped up on a fridge or by the bedside. And it's so that if someone stops breathing, goes into cardiac arrest, it's telling first responders what types of treatment that person does or doesn't want. Because first responders have a duty to come in and do their best to resuscitate. And so this form lets them know and protects them as well as the individual signing them to make sure that the person's wishes are granted. And so on these POLST forms, you can say, yes, take me to the hospital, and yes, admit me to the ICU. Sometimes people will say, okay, you can take me to the hospital, but don't admit me to the ICU. And then there's a choice that says, don't even take me to the hospital, just let natural death occur. Again, only appropriate for people who are medically frail or of an advanced disease.
Thanks.
Yeah.
You made me smile because my home state is Pennsylvania, and I attended a state planning seminar in Pennsylvania, and they replaced the P in Post with Pennsylvania. And then I read in your materials that the other name, physician, the P is actually physicians, but those crafty people in Pennsylvania. So
that's so funny. And then there's also like some states call it a MOLST. It's the medical order for life-sustaining treatment. Okay. So, as if like this wasn't all a lot already, to have multiple names for the same thing is frustrating, but yeah. Here we are.
Thanks. What happens if someone hasn't done either any kind of estate planning, and I think you alluded to this before, or has left things in an incomplete state? They haven't done the 4 foundational documents. What happens if they reach their end of life?
So, a couple things are going to happen. So the medical decisions are taken out of their hands. And so the healthcare team and perhaps the next closest relative will be making those decisions, whether that's what the individual would have wanted or not. And then in turn, once someone passes away, what would happen is their estate would go through probate. And I think, as I mentioned, probate's a legal proceeding where the court divvies up the property. And so it puts the courts will put a notice out to any creditors and debtors. The creditors get to take their piece of the puzzle, and then whatever is left over gets distributed by law. And the law is referred to as the intestate succession law. Every state has one. They're slightly different in every state. But essentially, it's dividing up the property to the closest family members in a particular order. But that, again, even if that intestate succession law is what that person would have done anyway, it's only a smaller piece of the puzzle now, or a piece of the pie, because probate costs, lawyers' fees, creditors. And so think about this, like if someone has had a lengthy stay at a skilled nursing facility prior to their death, and there is now an outstanding bill, that skilled nursing facility can come back and recoup their bill from the estate.
Right.
And so, it's also very hard on the family members who have to now navigate the probate process.
Right.
As compared to if there was a will or a trust.
Right. Yeah, I guess back to your point, sort of an act of love is putting this down and not leaving your successors or heirs in that position. I'm going to ask one more question, but I see some chat questions coming in, which is great. So assuming that some of the people on this call may have already drawn up estate plans and may have checked off the 4 foundational documents you talked about, when you review those, have you had the opportunity to review those that have already been drawn off? What are some of the weaknesses that you frequently find? Like how often should you review these documents? It doesn't sound to me like you just kind of do them and put them away and forget about them. And what's sort of the best way to go about making changes? And I think you even alluded to this, to cross out things. I think Aretha Franklin, which is one of the people that you mentioned that not having a will, did some of that. Tell us what we should do if we're in a group of already have done some of this.
Yeah. So first of all, I applaud you for having already done it. You are in the minority in this country. In terms of how often to review your estate plan, that's going to be very specific to each one of you. I think some general rules of thumb is anytime there are changes. So have there been changes to your family? Perhaps have people passed away that were in your estate plan? Have new people been born that perhaps should be added to your estate plan? Also, anytime there's changes in the property. So, if you've sold a house and bought a house somewhere else, like that's a good time to look at your estate plan and make sure that it's still how you envision it. So changes to your family. And then I think also thinking about how long ago you did it. Have your wishes changed? And here's where I see this happening, kind of two buckets. The first is someone who maybe did it earlier in life, maybe had small children, had very strong feelings about what their wishes were. And now they're, 75, their children are all grown, and like they feel differently about perhaps what they would want for their medical care, or maybe their children are in different positions. And so how they would divvy up assets might be different now. You've got a millionaire son and a son who's, I don't know, like a college professor. Maybe you want to like change how you divvy that up. So I see it over time where wishes change. I also see it where situation changes. So someone who is perhaps recently diagnosed, might be in the midst of treatment, starts creating an estate plan. Everything is sort of more acute in those moments. And then maybe they are through the thick of it and fill in whatever blank of stage they are in now. And maybe their wishes are different at this point. And I see that a lot with people who, maybe end active treatment and they kind of look back at their estate and they think that's not actually how I feel now that I'm through the thick of it. So those are my very general rules of thumb. I think if none of that resonates with you, pick a year. Every 3 years, I'm going to look at my estate plan. Every 5 years, like whatever makes sense to you. I don't necessarily think it needs to be annually, but not like 3 to 7, I would say is probably you don't want to really go more than, think about how much happens in 7 years.
Yeah, I think I have, or maybe I heard it in your seminar. I have a friend that sort of picked out a date to say, I'm going to either on my anniversary or birthday or Arbor Day or whatever it is. Yeah. That's a day, every 3rd year, every 5th year that I'm going to review those documents. And, the probably the more quickly you do it, probably the less changes. And the longer you waited, the more changes you're going to come across and say, oh, that person isn't in my life anymore. This has changed. So thanks.
Right. Absolutely.
All right. Let's tackle, we have some questions in the chat. Katarina Rook, I'm going to say, has asked if a house she had heard that a house is in a trust, and should there be an insurance claim? For example, property insurance, fire damage, that the insurance company can deny the claim because it's not in an individual's name, but it's in a trust. Is that true?
Theoretically, yes. The way to protect yourself, sort of the strongest way to protect yourself, is to make sure that when you go and purchase insurance on that property, if that property is owned by a trust, that you also name the trust as an insured. That being said, this has definitely come up in a lot of conversations in our legal communities since the California fires, that this is going to be a way that insurance companies try to get out of paying for claims. I suspect we're going to see a number of lawsuits if they choose to go down that route, particularly if the named insured is the trustee, because then it's a very clear line to why the individual was purchasing insurance on that property. But I do think if you were going into it fresh, asking for the trust to be a named insured would be a wise choice.
Good. Thanks. And Deb Parker lets us know that she lives in a death with dignity state, and her husband, who is the cancer patient, wants this option. And I think this is also called medical aid in dying sometimes. I think the same term. Is there a legal place to state this in his will, healthcare directive, or a form at his doctor's office? Any of the documents I think we just reviewed.
So medical aid in dying, death with dignity, terms that all refer to the ability to obtain medication to end, for the sole purpose of ending your life legally. It is not available in every state, just for everybody on today. But if it is available in your state, then that is something that you could include in your instructions for healthcare. However, I will share with you that in most states, one of the requirements to be able to access this medication through a death with dignity law is that you are able to physically take the medication on your own. So it would be something that you would have to be able to affirmatively say you wanted and to be able to physically take it. And so for people I have heard one suggestion from the Death with Dignity advocates is that people not wait too long to try to access the medication, because the other piece is that just because someone has accessed the medication doesn't mean they have to take it within a certain amount of time. But you just need to make sure that you've accessed it while you can still ask for it.
Thanks. And one of the topics that I hope that, and it's a hard topic because it's very state specific, and majority states do not have this law, at least in the United States. I'm hoping to have this on our list of serious topics if I can find the right person that can speak as broadly as we can about it without being specific. But I think it's a topic on. I talk to a lot of cancer patients. I think it's on a lot of people's minds. I know it's on my mind, and so thanks for raising that. Are there any? Those are the chat questions. Still have more questions, but if someone would like to, Linda, I think you can take yourself off the mute. Sorry, or Linda, you have to do that. But if you have a question, feel free to ask. Just come out and ask that. Thanks, Monica.
So I am just going to share that if you're curious about which states have those death with dignity laws, we have charts of state laws on a number of things, including which states have those laws. We also, and I'll pull the link in just a second, we have two resources that I just wanted to quickly mention. We have a chart of state laws around the requirements to create these documents in each state, because it is very state specific. We also have an estate planning toolkit. So it's state specific, it's all 50 states, and it's in 3 parts. So the first part describes these documents in a little bit more detail than I have tonight. It then has part 2, which provides the state specific information about how you create the documents in your state. And then the third part is if there's any forms that are like a fill in the blank form for your state, we've pulled those all together in one PDF so that you can print those off and look at them. So I will pull both of those links and throw them in the chat box right now so you have them.
Great. And I'm adding one as well. You referenced this in your seminar. It was the financial big picture document, which was really useful. I've gone into it, and let me get that up there. Hopefully, no typos. That's it's on a different triagehealth.org, but that's a great document for those of you who want to sort of think about, I guess, what your financial big picture is, your assets, your spending, all those kinds of things. So great. As you can see, this Triage Cancer organization has a wealth of resources. So feel free to take advantage of them. Does someone want to ask a question just out loud? Shy? Feeling shy? Peggy, I know you're not shy.
I have been thinking very hard about the do not resuscitate and how that's interpreted, and particularly sad because a kind of an old friend remarried a woman who told him, presumably in the marriage and before, that she would never take care of him if he got really ill. And I know it's lovely. And of course he did. He was a diabetic, if I remember all the details, and got very, very sick. And doctors wanted to do a diabetic response treatment. And she said, no, he does not wish to be resuscitated. And oddly enough, he died, and she got a big fat estate. And it's one of these cases that will probably make the news eventually. But again, I think the nuance question was, how do you make sure, if you're really so terribly, terribly ill, you're certainly going to die, the do not resuscitate makes sense to me or to a lot of people. But if an emergency surgery would salvage the situation, however you define that, and the person can go on living, how does in this case, the person could not speak for himself, and children were kept out of the discussion, etc. How can you protect your wishes in advance of need?
Yeah, I mean, absolutely. And I'm certainly very sorry to hear that story. That's exactly the purpose of the powers of attorney for healthcare and finances. So if he had written down what his wishes were, the types of treatment he did or didn't want, frankly, perhaps he should have named an agent that hadn't expressed that they weren't willing to take care of him. I mean, I don't mean to be flippant, certainly, but that's also why you can name an agent. And I made the point about a spouse, like maybe that's not the best person for whatever reason that is. Perhaps it's an adult child. Almost anyone over the age of 18 can be your agent. There are some limitations around like your healthcare providers. If you're in a facility, they can't, right? Because they're worried about undue influence. But other than that, it could be like the mailman. It could be your best friend. It could be someone at your religious institution that you're close with that would make similar decisions. So I think the distinction here, though, the do not resuscitate has a sole purpose, and that is to tell first responders, breathing stops or heart stops, do not perform CPR. That's all a DNR does. Whereas the instructions for healthcare, you can get much more detailed and granular. To your point, you could say, if medical treatment would, I'd have to think about exactly the wording, but like if reasonable medical care would allow me to continue living a full life, do it. Some of those fill in the blank forms have check boxes where you could say, I don't wish to be in a vegetative state if recovery is unlikely. And yes, some of these are still going to be judgment calls on both the healthcare team and the agent. But again, writing those wishes down can help them make some decisions. And I think the other thing I failed to mention, which I should, and it speaks to Glenn's question about like where you see pitfalls. Some people will name co-agents. Don't do that. Mm-hmm. Very rarely do I say do or don't do something. Do not name co-agents, because what happens if they disagree? Then it's almost made your documents useless. However, it is very wise to name alternate agents, because if your first choice is perhaps unavailable, then they will go down to the next choice and then the next choice. And you can actually name as many alternate agents as you'd like. But it just creates a clear line for the healthcare providers to know who I am going to next. And then even if people disagree, the healthcare providers can say, this is their primary agent. They have told me this. And so it just eliminates some of that confusion or opportunity for bad things to happen.
Thanks.
Yeah.
Thanks, Monica. Thanks, Peggy. Susan Kinney has submitted a question in the chat. Would you discuss, it goes back to the trust theme. This, probably many of us have heard of revocable trust versus non-revocable trust. Can you just talk about maybe the main advantages and disadvantages of each of those?
Yeah, so the revocable trust is the one that I was just talking about. So you put your stuff into a trust, you're a trustee, you're in charge, you can dissolve the trust, you can put things in, take things out. And it's completely flexible and changeable until the moment you pass away. Versus an irrevocable trust is one that as soon as it goes into effect, it's locked in. Can't make any changes, even during your lifetime. It is what you put in is what it's going to be. So why would anyone do an irrevocable trust? There are significant tax advantages to irrevocable trusts. There's also some added protection because they are insulated from certain things like lawsuits. So members of certain professions who might be more likely to be sued, for example, and their personal assets might be at risk. If they were to put their property into an irrevocable trust, then that property would be protected. But it's a gamble because you can't make any changes to it once it goes into effect. So I would say for a large majority of Americans, an irrevocable trust is not going to be the best choice for them. But I would say that if you have questions about that, or if something I've said resonates with your situation, I would strongly suggest talking to an estate planning attorney. I will also say, and this is just for trusts, because I don't think you do not need an attorney to create a will or either advanced healthcare directive or power of attorney. Those are all things that can be done DIY, as I say. There are some services that you can utilize. There's one called freewill.com, where you can create a will and I think a power of attorney. Don't quote me on that. You can for sure create a free will. It's an online system. Thank you, Glenn. I couldn't remember if it was com or org. So you can, it's a computer system where it asks you questions, and as you populate the answers, it then will create the will for you, and then you print it out and sign it and witness it. That's very DIY. The other resource is called Good Trust. And there is a cost to use that service. But if you use the code Triage30, you can get 30% off. And so I think it comes out to be about $100, but that service is a little bit more robust. So you can create your will, your powers of attorney, and a revocable trust all through that service. It also has some functionality where you can save all the documents in one place. You can invite Good Trust. You can invite your executors and your powers of attorney to the system so that they have access, should they need to your documents. So these are just some examples of lower cost ways where you can get some assistance and some guidance in creating these documents, but you don't actually need to go and hire an attorney. Because again, if you have a relatively simple estate, properties all in one physical state, you don't have a complex family perhaps, then these services, I think, are perfectly adequate to have valid documents. And it's just a misconception. I know a number of estate planning attorneys, and they hate it when I say this, but you don't need an estate planning attorney to make these documents.
Right. One of the high profile cases of an irrevocable trust, to your point, Rupert Murdoch, obviously a powerful, very wealthy man, created an irrevocable trust. And with all those resources, and for probably some of the reasons you talked about, probably likely to be sued, a lot of property, he is trying to get that changed because he no longer wants some of the people that were the trustees, I think it's a family member, to be that. And so far, he has not had a judge agree with him. So to your point, it's probably a good point to think about before you create the irrevocable trust. There you have someone with all the power and money in the world, truly not able to make that change. So, and we're giving a discount code.
I'm looking it up just to double check that I said it correctly.
I tried goodtrust.org and goodtrust.com, one word. I didn't get either of those. So
I will pull them up right now and get it for you. Normally I have the slides in front of me, so I don't have to remember those things.
Maybe Linda, maybe you can feel around also while we proceed with questions. Anyone else want to ask a question, or do you want me to draw from my question list? If you do to ask a question, take yourself off the mute. There it is, My Good Trust. Great, thanks, Dawn. mygoodtrust.com in the chat. And we have the discount code triage. I
believe it's Triage30.
Yeah, wow. Come to the seminar, you make some money. That's great. All right. I'm going to ask a question. For someone who's really just beginning thinking about estate planning, maybe we've accomplished our goal, we've created a spark for people to think about. What would you advise them? I mean, I don't think the first thing you're going to do is just start pen to paper, clicking away, doing these things. So what kind of thinking should someone start doing to inform that document preparation? So the thinking, what happens first is the thinking, and then you sort of get to the documentation, putting those things to paper.
Yeah, I think that it's often hard to start. That blank piece of paper can be daunting. So certainly using some of the resources we've talked about, but I think even before that, starting really big picture. So asking yourself, what do you want to have happen to the things that you own when you die? Are there people and or causes that you care about that you want to support in your death? And then if you're in a situation where you're unable to make decisions, whether they be financial or related to your medical care, who do you want to make those decisions on your behalf? And I think those are big questions, right? Those are not like quick things, but I think starting with that sort of, okay, I have 3 questions to answer, and literally like question 1, what do you want to have happen to your property? And start thinking about like, well, what is your property? What things do you care about? And who do you want to have them? And then it's about, okay, well, are there people, whether you're legally required to take care of them, like minor children, or just causes that you care about. So I know lots of people who want to use part of their estate to support their religious institution or their university or nonprofits or research or hospitals. And you can do that. You can make entities and organizations beneficiaries of your estate in addition to people. And so I think that also helps. So like, this is what I own and this is what I want to have happen to it. These are the people or causes that I want to support. And then finally, again, thinking about, okay, if I wasn't able to make financial or medical decisions, who in my space, in my life, do I want to step in to make those decisions for me? And then once you have those things answered, it starts to get a little bit easier to create the actual documents.
Yeah, and I think I didn't hear you say it, but I think a really tough question is like, how do you view your, like, where do you want to be in terms of your care as cancer patients? Your health may deteriorate to a point. At what point do you want to, continue to stay in that state? Not those are some really tough questions to ask, and
Absolutely.
probably all want to avoid them, right? We don't want to think about ourselves in that state, but it's probably worthwhile to think about those. Have those hard conversations with yourself and maybe others as well, but probably at least starting with yourself.
100%. And I will also say, not to minimize what you said at all, because you're absolutely correct. But to my point that like none of us know what's going to happen tomorrow. I could walk outside and get hit by a bus and be in a coma. So like even so even outside of the cancer diagnosis and the treatment and all of those things, none of us know. And that's really what this is all about, right? It's preparing for the unknown.
Thanks. I'm going to ask, I see that we've been at it almost an hour, so I'm going to ask another question and then maybe one wrap-up question, unless we have more from the audience. One of the things I found particularly confusing, and I think it possibly is confusing for other people in the estate planning, there are a lot of financial assets I have, where I name a beneficiary, or life insurance policy where I name a beneficiary. So then I'm thinking, all right, why do I need this will? Because I have all these financial assets and I've already done that work. And so understanding that distinction, I think, might be useful for our audience.
Thank you for bringing that up, because I didn't mention earlier that when we talk about wills, the distribution most of your property, there are those pieces of things that you might own where you've already named or you've already decided who's going to get it if you pass away. And life insurance is a great example, because the second you buy that policy, you say who's going to benefit, who's the beneficiary. Same with 401ks or retirement accounts, you're naming that beneficiary. So you wouldn't include those things in your will. But to my point earlier, I would venture to guess there are other things in your possession that you care about what happens to them. And that could be a music collection, that could be family photos, that could be, record collections, a musical instrument. Again, it doesn't necessarily have to be something with a large monetary value to it that you would put in your will. But you're absolutely right. Not every piece or kind of property gets put in your will.
And Gina, you actually took a question right off my list, so thanks for that. And I was going to ask about, I think solo agers is sort of the terminology I've seen. People that have not married. Gina says she's never married. She doesn't have kids. She does, however, have 3 sisters. And naturally, they're different. So she describes some qualities about the sisters in terms of their relationship with money. And her advice is, if you can answer it or feel comfortable giving some input, how do you factor that into your estate planning as to not hurt people's feelings? If there's an answer to that question.
Well, I think that I can say one thing with all of this, and then I'll address Gina's question directly. With all of this, it shouldn't happen in a vacuum.
Right.
Once you've thought through those hard questions and once you've put down pen to paper, then it is also on you to have conversations with the people involved. And that means anyone who is your executor or your guardians or your agents, like you need to have conversations with them about what your wishes are. But then also I think the people around you, because, you know, if you are considering, for example, availing yourself of a death with dignity law and you've never had a conversation with a family member and they find out how you passed away afterwards, that can be very hurtful and harmful. Or, for example, if property gets distributed perhaps unevenly, and there's never a conversation as to the thought process behind it, that can sow really significant rifts within family members. I know someone whose mother passed away, and she left the son more money than she left the daughter in her estate plan. And they don't know why. They think that it might have to do with the fact that while she was alive, she actually did quite a bit to support her daughter financially, where she never gave the son a penny. So one supposition is that here in her estate plan, she was kind of trying to even that out, so to speak. But because she never had a conversation about it, it leaves open a lot of questions and a lot of hurt and a rift between these siblings now. And so it is so incredibly important to have these conversations, even though they can be very, very hard. Now, to Gina, to your point, I think that it does come down to what your wishes are. And I think that, you know, obviously I know very limited information, but maybe it's about having a conversation with a sister that doesn't need the money to say, hey, how would you feel if this is how I addressed this issue in my estate plan? You know, I think that if you want to support the other two sisters equally, but you're concerned about how one would waste it, maybe you consider a trust and she's the beneficiary and you put very clear parameters around, you know, how she can use that money, pay off your mortgage or whatever, student loans or whatever, something that you feel like would be a wise use of that down payment on a home. And then that she only gets the money if that's what she does with it. So again, not easy in any of this. The other thing, just to throw it out there, is maybe you don't give anything to all three of them and you choose to support some other cause or organization or institution. Maybe you create a scholarship in your family name for a school or students. And so again, it's sort of thinking outside the box where maybe that would cause major problems between your three sisters if you distributed it unequally. And so maybe the better thing to do is to avoid it altogether. Of course, I am just generalizing and brainstorming with you, but I think my hope is that you can start to think about some other possibilities that, again, wouldn't cause family rifts and challenges.
Right. That's a great idea. And I was thinking as you were talking, you might not be able to avoid the hurt. You can avoid the hurt. You might not be able to avoid it live or dead, but maybe when you're alive, you can be part of that discussion and maybe you think creatively about it as well while you're alive. So
yeah, absolutely.
Question. Gina's asking, is there such a thing as a conversation agent?
Interestingly enough, like this it's not the first time we've gotten that question, right? Or we've heard of situations where, you know, the individual with cancer wants to have these hard conversations and the family members don't want to hear it. What they hear is you're giving up. Don't think like that. Be positive, be strong. I don't want to talk about this because you're still in it, right? which again, I hope we're all leaving today with like, that's not the point of this. We're not talking about end of life. We're talking about preparing. So it can be really hard, especially if the person you're trying to have the conversation with is not a willing participant. And so in those situations, it's about thinking about, can there be that conversation agent, and who is the best person to be? So I have to give a shout out to social workers. So if you are working with a social worker, ask them, hey, would you be willing to sit in and sort of mediate, for lack of a better term, this conversation, help facilitate the conversation? Other people who I think are really wonderful for this are religious figures. So priests or rabbis, because I think that then, if the family is religious, obviously, because they can kind of be a neutral arbiter and facilitator of this conversation, that can help sort of break that barrier to having the conversation. So again, I'm just giving ideas out here. It might be somebody different. Maybe it's a therapist, or maybe it's just another trusted family member or friend of the family to come in and help facilitate the conversation, because they are hard. Like, there is not a lot easy about this.
Thanks. I see one more question in the chat. So we'll ask that. I'll ask a closing question, and then we'll let Monica get on with her evening. So I think this is a relatively straightforward question. Dawn has asked if you have a preference: funeral, burial, cremation, all the things you might have to make a decision about when someone has died, and you have your wishes. What document can you use to stipulate what your wishes are, so that you aren't burdening your loved ones with thinking, did this person want to be cremated, buried, big funeral, small funeral, death announcement, not death, all the things that you have to think about.
All the decisions. Yeah. Couple different ways to do it. So one way to do it is that you outline those wishes, preferences in your advance directive. So many state advance directives have a section for what they refer to as final disposition. So it's sort of, what's the final outcome of your physical body. You can also include that information in a will. You can also do some pre-work for your loved ones. So many funeral homes and crematoriums have pre-planning services. So you can actually go to the funeral home, you can make all the decisions, and there are so many decisions to make, all the way down to plot, the exact plot you might want if you want to be buried, or if you're going to be cremated, what urn do you want? Like, all of those, you can make all those decisions ahead of time. You can, most of the time, set up like payment plans for that too, because funerals are actually very expensive. And so you can start to prepay that right now. Sometimes you can buy funeral insurance. It's not always great. And then if you do decide to go down that route, then the funeral home or crematorium keeps all of that information on record. And you could also keep copies, and make sure that your executor has all of that information. And really, you could just point to the funeral home in your estate planning document so that your loved ones know, all I have to do is go. And many times it's like, all you have to do for the funeral home is say, this person has passed away. And then the funeral home or crematorium kind of takes over all of it. And we talk about a loving thing to do. Man, is that a loving thing to do? I will never forget a gentleman I spoke with who was in a tough financial situation. His wife had passed away from cancer, and really he was drowning in all the bills and whatnot. And we kind of were talking through it, and it came to light that he spent a significant amount of money on his wife's funeral, and that he bought a very expensive coffin, and he spared no expense on the funeral. And in a very non-judgy way, I asked, like, is that something that your wife, if your wife had made those choices, would she have made those choices? And he said, absolutely not. Like, she would have said, put me in a pine box. What does it matter? But because they hadn't dealt with all of it, in his grief, the guilt, the whatever, I don't even want to name the feelings for him, he made decisions that then put him in a really challenging financial situation. And so it's just such a stark reminder for me that, again, by doing the hard stuff, like who wants to go pick up their coffin? Nobody. But by doing that ahead of time, how much would that have helped that family moving forward? So those are kind of my 2 cents. It's, again, none of this is easy or fun or joyful, but it is reality.
All right, so closing question, and then we'll let you go. And I'm thinking more, when I think about the goals that I had for this seminar, was someone who hasn't started at all. And maybe there's some people on our screen now that haven't done that. The odd statistics would say there probably is. And I attended a course about like sort of organizing your time. It was a time management course. And the concept was, understand what is the very next thing you need to do. Rather than thinking like, oh, I gotta write a will, which is a huge task. And it doesn't have to be in the will. Like, what is the next thing that someone can do that hasn't done any of this to help them proceed? Do you have a piece of advice?
Yeah, I think it's one of 2 things you can choose. It's downloading that state-specific estate planning toolkit that I just put in there and printing it out and reading through it. Or it's starting with a piece of paper and the 3 big picture questions.
Okay.
I think either one of those first steps is a good first step. But you're absolutely right. It is a daunting thing. You can't take it all on all at once. You do have to do it in steps. And so I think one of those 2 steps would be a great next step.
Thanks, Monica.
Well, thank you all. I really appreciate you inviting me on and for the wonderful questions. And certainly please avail yourself of the resources on triagecancer.org. They're all free. We have recorded webinars, so you can certainly learn more if desired.
Absolutely. It's quite easy to see why 1,000 organizations have asked you to do a seminar. You are clear speaking, so knowledgeable. And I think this audience and audiences that will view this afterwards will benefit so much from that. So thank you, Monica. Thank you to Judy Nicholson Foundation for allowing me to kind of proceed with this vague idea I had a few years ago. So thank you. And with that, we'll wish everyone a good night. And Linda, anything in the last bit you want to cover? I saw you put something in the chat about a survey.
We're going to be sending a survey out to everybody who attended. And if you would just fill it out and put your comments, I'd really appreciate it. It helps us know where to go to.
Thank you. Good night, everyone.
All right. Good night, everyone.